Welcome. In this video, we'll go through question ID HBP-PAT-1010. The degree of difficulty for this question is assigned to be at 70 out of 100. That's about the average for a typical patent bar question. You will have about 50% questions at that level, 25 below, and 25 above. As usual, we'll go through the fact pattern of the question, call of the question, followed by answer choices. Then we'll discuss correct answer and wrong answers and why the correct answer is correct and wrong answer is wrong. And finally, I'll leave you with more information that you should review and make notes. So let's begin at the top, the fact pattern of the question. Sal is an inventor here. She invents a nail polish and a special nail remover. She files a patent application with two claims. Claim 1 is addressed to nail polish and claim 2 is addressed to nail polish remover. She files the patent application on a particular date. As always, we highlight the filing date of the patent application. The application contains an abstract, specifications, diagrams, and claims. So let's keep that in mind. What it contains may not be necessary. Maybe we don't know yet. The examiner here issues first office action rejecting her claim 1 under 35102 and claim 2 under 35103. So we highlight rejection. Practitioner discussed this with the client and they came up with a game plan. The game plan is to file an amendment. So what do? In the amendment, they file an amendment where they change things around to make it better, so to comply with examiner's suggestions. So let's see. Amendment included changes in the specification. So we highlight that. To overcome novelty, the 102 rejection for claim 1. Changes were part of the abstract, so that sounds interesting, and it was now moved into the specifications. The amendment also included changes in the wording of claim number 2. So now we are changing the claim 2 itself, what it had in terms of wording, to overcome the obviousness rejection. So they probably made it more specific, made some changes essentially to the claim 2. Examiner correctly, whenever you have that kind of language, correctly highlight that. That means it's not arguable. Examiner did that correctly. Identified that the new range in the amended claim 2 was not covered by the original specification. So claim 1 has some changes in the specs, claim 2 has changes in the claim language. Examiner correctly identified that claim 2, whatever was changed, the new range was not part of the original specification. The call of the question is, which of the following action taken by the examiner is in accordance with USPTO rules and guidelines? And we are given 5 different choices. So let's pause for a second and understand, what does this question turn on? What knowledge, what patent law knowledge is necessary to resolve to answer this question correctly? So let's make a list and go through that. On your right, we have that list. So this question turns on, what is a new matter in a patent application? What's a new matter, right? You need to know that to answer this question. Is a new matter permissible in a patent application? Is it ever permissible? You need to know that. What should examiner do when faced with a new matter in a claim? What are the examiner's options? How do they handle new matter in the claim? In the patent application, claim, or specifications. What should examiner do when faced with a new matter in the specification? So when faced with new matter in the claim here, and then new matter in a specification. So that there are different things examiner is supposed to do. So we need to know that in order to answer this question correctly and get the full credit, full points, and pass this exam. So now let's turn our attention to the explanation and answer choices. So let's look at that. The first choice here is examiner should issue an objection to claim 1 and 2. Examiner should issue objection for claim 2 under this as a new matter. Examiner should issue a rejection of claim 2 under 112A. Examiner should issue rejection of claim 1 and claim 2 because abstract is not part of the specifications, or examiner should issue objection for claim 1 and claim 2. Okay, so what should examiner do? So let's look at the correct answer and the explanation and why the other answers are incorrect. So we'll turn our attention to that. Let's go down here to brief explanation, and we will have our highlighted text up here. Okay, so application was filed on March 20th. When application is filed on March 20th, what does it mean? AIA is applicable. So we'll say AIA. We are in AIA range here, AIA. That means this patent application will be examined under AIA patent law. So let's look at the brief explanation on your left here. C is the correct answer. Let's look at why C. C is the correct answer. C says examiner should issue rejection for claim 2 under 35 USC 112A as a new matter. So what is the law there? The law is that new matter, whenever the new matter is added, right, is a new matter added, first of all here, that's, you have to resolve that. But when examiner finds that new matter has been added, the rejection is proper under AIA 112A when new matter is added to the claim, not the objection. Furthermore, abstract is held to be part of the patent application, and information contained in the abstract can be moved around without being called new matter. So what happened here? Let's go back to our fact pattern. So they got the rejection here on your right. Examiner included changes, so they made changes to get claim 1 through to avoid the novelty rejection under claim 1 for the claim 1. So they made some changes. They moved stuff around from abstract into the specification. Is that a new matter? Answer is no. That is not a new matter. So claim 1 is okay. What about claim 2? They made some changes, and examiner, remember? Examiner correctly identified here. Examiner correctly identified here. Let's see. So examiner correctly identified the new range. So correctly is the keyword. That means we're not arguing. Examiner is right. It's given that the language that was amended in claim 2, the range wasn't part of the specification. Therefore, it is considered new matter. When there's a new matter in the claim itself, what's our recourse? The examiner should issue a rejection, not the objection. Let's go up. Answer C, examiner should issue a rejection for claim 2. What about for claim 1? Claim 1 again, no new matter was added, so neither objection nor rejection is necessary. So let's look at the other answer choices. Choice A is incorrect because, as you can see, we already went through that it's a rejection for claim changes, an objection for specification, anything new matter in the specification, but there wasn't any new matter. The answer B, therefore answer A. Let's look at answer A choice on the right. Examiner should issue objection to claim 1 and 2. No, claim 2 should be rejection. Claim 1 should not be either objection or rejection. Answer choice B. What is the answer choice B? Examiner should issue objection for claim 2. No, we already talked about rejection for claim 2 under 112. The objection is under 132A, not 112. Answer choice D. Let's look at D on the right. Examiner should issue rejection for claim 1. No, it should be objection if it was a new matter. It wasn't a new matter. The matter was already inside the abstract, was rearranged, moved into the specification. So it's not a new matter, therefore neither objection nor rejection for claim 1. And then choice E here. Let's see, examiner should issue objection for claim 1 as well as claim 2. No, we already talked about it. Examiner should issue rejection for claim 1 under 112A. Because of the new matter in the claim, and neither rejection or objection for the claim number 1 because it was not a new matter. More information, MPEP 706.030. Look for that inside the MPEP. You can also do Google search, new matter, MPEP 706.030 USPTO, or you can do site:/uspto.gov as well. If you have any question, use the Q&A forum here, as well as 7 different ways we have provided you to reach out to us and engage in a conversation. Remember, there's a statistics out there that one who engages in a conversation about learning increases their chances of passing this patent bar or any licensing exam by 2 times. So one who engages in conversation is twice more likely to pass. highly encourage you to engage in a conversation about this topic and in general be active about it so you can learn faster. Thank you. Welcome. In this video, I'll recap question ID HBP-PAT-1010. Now, this question is about new matter and what examiner is supposed to do when faced with a new matter in an application. So first of all, what is a new matter? Well, new matter is a matter that was not part of the original application, either in the specifications or in the claim or somewhere in the application. Now, this new matter has to be substantive, meaning it has to change the meaning of the claim, the application itself, the scope of the rights that patent owner will receive. It has to change that. If you change full stop or a comma or something, punctuation, that's not new matter. And oftentimes if you change, you add substantial new information, that may not be new matter either, because that may be just explaining what's in there, right? It cannot just change. The new matter is the one that it cannot change the rights received in the end by the patent owner. Okay, so keep that in mind. Now, when practitioner or the applicant makes amendment to the application, there are chances that that amendment might introduce new matter, like changing the range of chemical compounds or something that wasn't there, which changes the effective rights in the end. When that happens, examiner is supposed to follow certain rules. Here is the main rule that you need to understand. When there is a new matter in the claim itself, examiner is supposed to issue a rejection of that under new matter using AIA 112A. So when there's a new matter in the claim itself, rejection should be issued under 112A. And when there's new matter in the specification section, rest of the application, that's when examiner is supposed to issue objection. In that situation, objection, not rejection, objection under AIA 132A, okay, not 112A. So once again, claim new matter, rejection 112A, specification new matter, objection 132A. Very important topic. New matter is being heavily tested. Expect about 3 to 7 questions in this on this topic in your exam. Not very difficult. Make sure you understand it well and master it. Once you master it, you should get these points fairly easily, and you will feel comfortable about it. Strongly encourage you to go through the PDF for this answer for this question, as well as participate in a Q&A forum, as well as discussion forum. I'll see you soon. Thank you very much.